the presentation we have today is on the Welfare and Institution Code, specifically all of the various psychiatric holds that exist within the Welfare and Institution Code. We have two presenters who are well known to some of you and well known to our inpatient unit team very much so. We have Julian Sapirstein, who is the hearing officer for the hearings that we have here at Langley Porter, as well as next door at the medical center. And I like to call Julian Judge Sapirstein, but I think technically it's hearing officer. It's how it's stated. And Daniel Meyer, who's the public defender at Zuckerberg San Francisco General Hospital. But we also have Greg Bryan here, who is also functions as the public defender, although I think it's a slightly different title.
Private defender.
Yes, okay. So well known to us here on the inpatient unit. So Dan and Julian have a PowerPoint, but I think they invite people to just raise their hand and ask questions. It's a very open type of discussion, and this is a really great opportunity to bring up all your questions, concerns that you have as you make your way through doing, working with patients who are on legal holds, and in whatever setting, the med-surg setting, the emergency room, or right here at Langley Porter. So with no further ado, I'll turn it over to Dan.
Good afternoon. It's good to see some familiar faces in here. I want to make, I have a PowerPoint, but it's, a lot of this is sort of nuts and bolts of, the civil commitment process. And a lot of it is what you guys are already going to know. So if there's questions, I want to make this a useful tool for you. So if you have questions, feel free to ask them along the way, or right off the outset. This should be full conversational. So whatever you guys want to do. Obviously, I have Commissioner Sapirstein here, who many of you know, and we really are fortunate to have him as our hearing officer in San Francisco. I've run that through experience of having some other hearing officers lately who don't quite have the same finesse, and it can end poorly with assaults and blowouts. But so we're lucky, and it makes me really appreciate the touch of a hearing officer who makes patients feel like they're being heard during their hearing. And I think we have a lot more problems in the course of hearings and following hearings if it wasn't the case that Judge Sapirstein really made, even when ruling against clients, really makes them feel like they've had an opportunity to present their case, to that he's listened to them, that he's heard them, because I think that when you do that, clients will leave the room feeling good about the outcome, even if the outcome is not what they went in wanting. So I had to put this up. We have no conflicts of interest, I don't think. Nothing to disclose. Does that mean like we're not paid by pharma companies?
Exactly.
Okay. So here are some of the nuts and bolts. I think most of you already know this, certainly Greg, you already know this. But just as a reminder, the civil commitment process starts with a 5150, which is a 72-hour hold. Recently I heard one of the lieutenants who helps facilitate the crisis intervention team training refer to it as a 72-minute hold, which I guess they're fond of. Sort of, emphasizing how hard it is to get people into treatment in the city. So following that, you have the 5250. It's a 14-day hold, which a lot of you are familiar with. And then the holds start to diverge for different purposes. So if someone is suicidal, there's a specific hold for that, the 5260, which is an additional 14 days. And then if someone is a danger to others, there's a specific hold that we don't use very often, but available for that criteria. And then recently, I think thanks to the efforts of Judge Sapirstein, we've started using, I guess it's recently, it feels recently, but
About
it's
2 or
really,
3 years now.
is it really?
Yeah.
We've been using 5270s in place of conservatorships, which I think has been working. Do you all feel like that's been effective? It definitely helps us because patients don't feel like they're being conserved, and it's sort of less of an extreme, you know, if the only option after a 5250 is a temporary conservatorship, but the doctors only need a couple of days, that can be troubling for a lot of people who now feel like, oh my God, what is this beast that I'm facing, which is a conservatorship, as opposed to just another 5270.
One nice thing about 5270 from a lawyer's point of view is oftentimes lawyers really want to know what is the legislative intent behind this particular statute. And then you don't know, you might have to go and look in minutes of meetings and you'll still not know, but it's written right there in the statute 5270. They say this statute is for people who need a little bit more than the 14-day hold, but probably not more than 30 extra days. And we don't want to put them on a conservatorship if we can do it this way. For whatever reason, they allowed the counties to accept it if they wanted it, but it doesn't take effect unless the county actually enacts it. And as Daniel pointed out, it took a lot of work for us just to get it to the attention of the Board of Supervisors. But once they did it, it worked very well.
I think it's good for clients too. It gives them more opportunities for judicial review. So not only do we have another probable cause hearing in the hospital, we can also have the opportunity for a writ on that. Whereas on a temporary conservatorship, you would only have the opportunity for a writ and no opportunity for a hearing in front of Commissioner Sapirstein.
Makes it a whole lot easier for the doctor too, because two things. Filling out paperwork for 5270 is easy, and a conservatorship is hard. And second, you don't have to go tracing down to Psychiatric Court. You can do it right there at the unit with me.
So I have two questions. So just to clarify, before it would be a 5150 to a 5250, and then
T-con.
to a T-con, right? And now it's a 5250 to a 30-day 5270, and then from there a T-con.
So the purpose initially wasn't for that to happen. It was if you knew that you were going to put the person on a temporary conservatorship, then that's supposed to happen earlier. So yeah, during the 5250, if you know at that stage. Really the purpose of a 5270 is to try and avoid a T-con because they're expensive judicially, you know, just the processing of it takes court resources. And so it saves costs, but also, you know, as we said, you know, patients feel better about more of the same as opposed to this new conservatorship idea.
And one thing that is important to remember is if you do go from 5270 to T-con, you don't get an extra amount of time. You have to file your T-con within the 30 days of the 5270. So, in fact, you have to file 5 days earlier. So, it doesn't extend anything. It just means that the purpose of 5270 hasn't been fulfilled, and you go to T-con. So generally, the legislature, by their express legislative intent, would like 5270s to finish without a T-con.
If this is too much in the weeds, that's okay, but could you briefly touch upon gun ownership under
Sure,
each of the holds?
it's coming, but we can talk about it now.
Oh, okay, great. We've had some upset patients
Yeah.
find out.
That their rights were being violated, or not violated, but restricted. Yeah, so any patient that's hospitalized on a 5150 for either danger to self or danger to others has their rights restricted, so they cannot own a firearm for 5 years in the state of California. Federally, I think it's for life, but
Not on a 5150.
Okay,
because it's not a
52 is for
judicial.
life.
It has to be a judicial adjudication.
okay.
And so there's a sustained grave disability that loses the patient's federal right to a gun ownership
Yeah,
for life.
for life. So on a 5250 statewide, if let's say you come in on a 5150 for just GD, for just grave disability, then you don't lose your rights unless and until Julian signs the orders for a 5250, and then you lose your rights for 5 years. Either GD, danger to self, danger to others, at all grounds. So any 5250 that's signed, you lose your rights.
At time of discharge, the patient is given information about this and how they can contest it if they would like to.
Right. So that's, if a patient's getting upset with feeling like they weren't aware of this, and now all of a sudden, we had a client who felt like he needed it. He was a security guard and felt like he needed it for his work. They do have the opportunity to go petition for their rights back. They don't get appointed a lawyer for that process, but it's something you can give them to say that it's not over for you. This doesn't, you have the right to appeal this. Any other questions?
I'm not an advocate of gun ownership, but I do find it kind of amusing that under federal law, a person on a terrorist watch list has a right to buy a gun. But a person who's been held on grave disability because they can't feed, clothe, and shelter themselves loses it forever under federal law. It's an interesting contrast. I'm sure the NRA would have something to say about that.
And the client who I had most recently, who was the most concerned with his gun rights, that ended badly with a standoff and him shooting himself and his mother. So, not for nothing, but that's. So these are the definitions. We can run through them if you like. But they may be helpful. So the definition of danger to self is not actually defined in the law, but this is the guidelines: is that it can be manifested by actions that place the person in serious physical jeopardy. If those actions are caused by mental illness, can be manifested by words expressing an intent to commit suicide, intent to inflict serious bodily harm on oneself.
One thing that's important.
In your experience, has any of this changed in the hearing since there was the clarification that, first of all, it doesn't have to be imminent, and second of all, you can rely on history? Has anything changed?
I've always done it that way anyway.
Right.
So the law does make it more clear, but it's more of a clarification than a change in the law. But one thing I think that is important to know is that under 5250, danger to self includes somebody who walks into traffic thinking that he has an invisible force shield and won't be hurt. But under 5260, which is an additional 2 weeks, it has to be, it's written right there in the statute, suicidality. In other words, if he still believes that he can walk without danger but isn't trying to hurt himself, 5260 doesn't apply anymore.
So I used to make the argument that the person walking into traffic isn't a danger to himself because there was no intent to harm himself at that point. They were just disorganized, or for whatever reason they put themselves in danger, but not intentionally trying to hurt themselves. That no longer flies, at least on a 5250, because that will now qualify as danger self. Yeah, I don't think anything changed with those additions. The jury instructions for grave disability have always included history as a consideration for when you're considering present grave disability.
I think it was changed because in some counties it was interpreted, they didn't have Mr. Sapirstein, and it was interpreted very differently.
I've been to a number of meetings of the LPS hearing officers, and the variety of opinions is kind of mind-boggling. I stopped going because it's kind of frustrating.
And I don't think they had Reese's in other counties until recently, or they didn't have Affidavit B's So anytime someone was placed on a conservatorship, they would automatically lose their medication rights until the last few years when the Meredith case came out and they started actually respecting people's medication rights, which we've been doing in this county already. Okay, more definitions. Danger to others, not defined by statute or regulation, those also not written in the law. Can be manifested by words or actions, evidencing a serious intent to cause bodily harm to others due to a mental disorder. If it is due to words, i.e. threats, the evaluator must believe that it is likely that a person will carry out the threats.
I actually tend to disagree with that one. There's no case law that I've been able to find to support my position, but on the other hand, the statute, I think, is loosey-goosey enough that if a person thinks that he can drive 80 miles an hour through a school zone because he has incredibly sharp driving skills, I can consider him to be a danger to others. I can also say that I don't recall having done so, but I think that it's within the scope of my authority to find a person who has no intent to harm, but is behaving in such a fashion as to put others at risk because of a mental disorder. I think he would fall under the definition in the statute of danger to others, without an intent. But that's something that I can't say I could prove in another court of law. It's got my court, I get to decide.
Can I ask a question about the definition of mental health disorder or mental disorder or mental illness? Is it still the case that the different superior court jurisdictions vary in what's included or not? Because
Absolutely.
It's been a while, but there were, I think it was Santa Clara County that, I'm getting the county mixed up, said, a dementia is not a mental disorder, and others said it was.
It's about that's one thing I did pick up from going to the Calypso, they're called, meetings. There's a wide variety. I would say probably about 50-50. Half of the people doing my job think that dementia is not a mental disorder, and I'm in the other half. I think it is. I mean, if a person can't find the way to her room, I think, and it's because of dementia, I think that's a mental disorder. She's unable to be carefully put in a shelter, and I think that is grave disability. But the reason that people don't like to call dementia grave disability is they don't want to get LPS involvement. They think this should be handled by a dementia unit. And that's more of a practical consideration. For me, I look at the evidence. If the person is demented to the point where they can't take care of themselves, I think they fall into the category. But not everybody feels that way.
So I had a case a few months ago of a longtime client who has HIV and HIV dementia, neurocognitive. Somebody help me. Come on.
That's right.
Okay. So he has that and also carried a diagnosis of, it was either bipolar or schizoaffective, but it was sort of unclear because he used crack, and so every time that he presented, it was a messy, murky diagnosis. So the doctor that he'd been in the locked facility for some time, he was in Crestwood, Idlewood, I think, and the conservator's office hired a doctor to go evaluate him and then to come and testify for the renewal of the LPS conservatorship. And this client didn't want to stay in the locked facility, he wanted to leave, he wanted to get off the conservatorship. So he came to court and we fought it, and the doctor testified that he didn't think that the bipolar diagnosis was genuine, and that was mostly a result of seeing the patient after being intoxicated, and that he thought his true diagnosis was HIV dementia. And so I made the argument exactly as you're saying it, that dementia is not a mental disorder as it relates to an LPS conservatorship. And the judge, frankly, didn't know what to do. So he didn't decide. He had us brief the issue and then submit them and then come back and he'd make his ruling the following week. So we did that. So I did some research on, and there's not a clear answer, but my position was that because there's a separate code section for probate a probate conservatorship with dementia powers that specifically addresses the needs of individual with dementia. And dementia doesn't respond to treatment the same way that schizophrenia or bipolar disorder or schizoaffective would. That this code section was really the vehicle by which you conserve someone with dementia, and therefore he should be, that should be the appropriate vehicle. The issue, I think, with this client was that he was very disabled. He was in a wheelchair. He didn't really have the ability to take care of himself. And so the judge was faced with this sort of decision of whether to set this guy free because of maybe a technicality in an interpretation of the law, and he chose not to do that. He encouraged, his ruling was very wishy-washy, he encouraged the conservator's office to explore whether a probate conservatorship with dementia powers would be more appropriate. And they did, but ultimately felt like this was the right setting for the client.
Well, my position is that people behave because of their brains. And you've got schizophrenia, you've got bipolar, and schizoaffective, and all of those things, people say, well, something's going on in the brain and we're not quite sure what it is. But with dementia, we know that person is just, he's not firing on all circuits, but it's still the brain, and my position is the brain is the source of a mental disorder. That's my particular position. I think that one of the other reasons that doctors don't like having dementia fall under LPS is because dementia is so untreatable. You can deal with schizophrenia, you can deal with bipolar, but dementia, you basically say, Aricept, it doesn't work, but we can control the patient. And so that may be part of the philosophy, but as far as I was able to tell from reading the case law, which is minuscule, there's no clear and definitive answer about this.
And so at a practical level, you have to know if you're going to be filing a longer term thing, what's their residence or
Exactly. It becomes a placement issue, I think, ultimately, and what is the right place for this person. It's very similar to someone with developmental disabilities, where if you can conserve them if they need that level of care, but then you need to find an appropriate place for them, and a psych facility is not going to be the appropriate place.
Or on a practical level, give them a psychiatric diagnosis, a depressive disorder, secondary to dementia, psychotic episode, impulse control disorder, something like that.
Traumatic brain injury, it comes up with that as well, where there's some confusion about, whether a psychiatric conservatorship is the right vehicle. Did we do the GD definition yet? Let's do it. Patient has a mental health disorder, and the way that's defined in the law, at least, is just any disorder that is in the DSM. Cannot provide for basic needs of food, clothing, and shelter because of that disorder. And in parentheses it says there cannot be because of a chosen lifestyle or lack of funds, and I think that's important to note. And then patient is unable or unwilling to receive meaningful treatment voluntarily.
One thing I'd like to say about grave disability is I've had to deny quite a few petitions on GD recently, and it seems to be an increasing number for some reason. I don't know why, but just this morning I had a young man, 19 years old, who is having his first bipolar break, according to the sketchy evidence before the court. I mean, this guy is about to lose everything he's got. And what am I supposed to do? His brother says, oh, I'll take care of him. I don't want him to be in the hospital. I'll take him against medical advice. So food, clothing, shelter, he can take care of him. He can be taken care of. Somebody's willing to do that. I have no choice but to let him go, even though it's going to have a catastrophic influence on his life. He's a student, he's going to lose his scholarship, and that's what happens. And it's not a unique case. I've had quite a few of these in the last several months, and I don't know why they're so much more common these days, but it happens a lot.
Well, isn't a factor to consider in that particular case whether the patient is willing to accept the brother's help, and that the stated willingness is trustworthy or reasonable?
Absolutely. But there was no evidence to contradict. He said, yeah, I want to go stay with my brother, he'll take care of you. And there was no evidence to indicate that he couldn't, that he wouldn't be able to do that. And it was still a disastrous thing for him to do. I didn't have the wiggle room to rule against him.
Do you think specifically for people in a manic episode that the law will change? In that, we have a number of people who they're able to articulate some plan in the throes of really severe mania?
Oh, I definitely evaluate these, whether the plan is solid in mania. The trouble I have with mania and GD is something that I don't think the law is going to change to fix this problem. But you have a person, say they're 62 years old and they've built up a life. They've got savings, they've got a house, they've got a car, and they're giving it all away. They're buying things that they don't need. They're inviting homeless people into their home. The way the law works, as it's currently fashioned, is after they've gone through everything and they've become destitute because of all of these bad mistakes, then they're gravely disabled. But until that time, you just have to stand back and watch them dissipate their life savings. Unless, well, sometimes I will bend the law a little bit, but if they're behaving in such a way that I can say, look, he's just not making good use or adequate use. Good use is a different story, but sufficient use to beat grave disability. And it is what I consider to be an issue in the law that really we're not able to address people with bipolar disorder in the way I think might be in their best interest.
I think I see things like a sort of a shift in the direction of, we have assisted outpatient treatment now. And I think that represents a shift where, there is this frustration around, well, he's not gravely disabled yet. Technically this person is ruining their life, but they don't meet the criteria to be forced to do anything. And assisted outpatient treatment sort of softens that. You don't have to be to the level of gravely disabled in order to be court-ordered into treatment in that program. So we're seeing a lot of those. The problem with that is that you can't, even with the judge ordering someone to engage in treatment, as Ms. Livingston knows, they don't have to. And we had a client come out of St. Francis, who probably some of you worked with, who wasn't really taking care of his leg, wasn't making his medical appointments, getting in fights with his neighbor. I'm seeing some smiles. And so they decided they were going to petition for outpatient treatment for this guy through AOT. And we fought it. He was adamant that he didn't need it. And we fought it and lost. And he was court ordered into treatment. I don't know, how many times did you go to his house?
1 to 2 times a week for 6 months.
Yeah, for 6 months. And did he ever come to the door?
The last 2 times.
And what did he say when he came?
Oh, inappropriate that you're here.
Yeah, that sounds like him. And so he never engaged. Oddly enough, he made every court date that he was asked to. He was on time, he was early actually, and just sort of sat there politely when the judge would say something, he'd say, no thank you. And then, we would get through it and the judge would be like, I'd really like you to meet with the case manager, and he'd say, no thank you. Until the last day, and then he had some words for them about why this was all their fault and this should have never happened in the first place. But yeah, there's no real teeth to it. So it's a civil order, and it relies on the black robe effect, where someone does something because the judge orders them to, which actually works in a lot of cases. I see Judge Sapirstein order people to take Depakote and lithium through a REIS order, and even though there's no IM backup, they do it because there's a court order to do it. I think it can be different in an inpatient setting where there's motivation to get out of the hospital and just to sort of go with the program to do in order to get out. But I do see a shift towards, I know the city is desperately trying to deal with the homeless situation. And so there's a lot, and they want to deal with car break-ins and all these little things that directly impact our clients. And so there's a shift in how they're approaching that. And we're in the public defender's office staying on guard to make sure that they're not, I hear a lot about sort of how other countries deal with their mental health issues, and I hear the Netherlands does it really well, and there are case studies on other places, but I think those places give up a lot of individual civil liberties in order to address those issues. And so it's always sort of a balance and a trade-off. And in this county and in the state right now, we sort of drawn a line, but there's still a problem. And so that line is seeming to become more flexible. Anyone else feel that way? I mean, I'd love to hear comments on this. You guys work in this business. Yeah.
No, I was just wondering, do you prefer that people come into the hospital on a voluntary or an involuntary basis if they meet the criteria? If they're, let's just say they're suicidal, but they say, I'll come in. Because it used to be that people in the public defender's office would say, don't put them on a voluntary, because they really can't leave. I mean, the second they say they're going to leave, you're going to put on a 5150, and that if they meet the criteria, just put them on the hold, then we'll meet them, their civil rights kick in, and you'd be much, they can have a hit. I'll visit them, and explain it. Otherwise, you're just playing games with them.
Yeah,
although the statute says it's, voluntary is always better. So just wondering if that's shifted.
Well, my personal opinion is that voluntary is always better. Though if it's the doctor's position that they're never going to let this person leave, or not never, but that there's no intention to actually make them voluntary, then I think that's an issue. If it's sort of a false promise that this person is voluntary, then that's misleading. But I would always prefer voluntary treatment.
Even if they meet the criteria?
Yeah.
Okay.
Yeah. And even if someone's incompetent to refuse meds, if they're taking their meds voluntarily, I prefer them not to be released. Because I think the more agency and empowerment you can give people, especially in the mental health system, especially young people, the more likely they are to continue to engage in that system and not, it not have sort of a chilling effect where people are reluctant to seek any treatment at all because they feel like as soon as they enter that building, they're going to get locked up and their rights are going to be taken away and they're not going to be free to leave. So the more we can empower people to feel comfortable in that process and have agency in that process, I think that's always better. Back to the slides, I guess. You probably all already know this, but the standard that we deal with grave disability, danger to others, danger to self, it all is only based on a present state of mind. So I think a lot of the frustration, even what I was just talking about, the police trying to deal with homeless issue, the city trying to deal with it, their frustrations around not, calling it a 72-minute hold and these type of things really stems from this issue that you can't hold someone just because of history. Even though history is a relevant consideration, it's only a consideration. It's not the criteria. You have to be in that present condition. So grave disability has to be present. It can't be that you were totally psychotic.
That's he just dies.
So it can't be, and that can do a lot with drug intoxication where it wears off, right? And then they're no longer psychotic, and where they might have been running naked in traffic a day earlier, they're not in that state of mind anymore. They're no longer holdable.
One thing I'd like to bring up is just one of my pet frustrations is about present. The California Supreme Court, this is on a different thing, but what I'd like to say is, in my court, I take this seriously. I don't think they do in psychiatric court here. And I'll give an example. There's a thing called a Murphy conservatorship. You're probably all familiar with it. I was sitting in, substituting for the judge in psychiatric court on a Murphy conservatorship. And the person was already on an LPS conservatorship and was at Napa, had been there for 7 years, but the prosecutor wanted a Murphy. And the California Supreme Court many years ago said, in order to get a Murphy conservatorship, you have to prove that the person, beyond a reasonable doubt, is likely to go out and hurt somebody if you don't give them a conservatorship. So the fact that the person may have done something bad in the past is specifically irrelevant. You only think what's happening now. The prosecutor put on his triumphant evidence that she had been in a dispute with another patient, and the other patient whacked her in the face. She got up and walked away. Okay? And then there was another dispute, and neither patient hit each other. That proves that she was, beyond a reasonable doubt, a danger to others if she didn't get the Murphy conservatorship. And I ruled against them. I said, there's nothing there. And the prosecutor, you could see the steam coming out of his ears. Apparently, from what I've been told, that the other judges would have sustained that Murphy without a second thought. And so what I'm saying is, if you go to psychiatric court, that's the law, but it may not be enforced.
Murphys get complicated because there's an underlying serious felony case, usually violent, that the individual is incompetent to stand trial. And so that's still not resolved. It's sort of floating out there where a person is charged with this, they're not competent to stand trial for it, so what do you do? And it could be as serious as murder. We have clients on a Murphy who have killed people, and you know, they can't go not guilty by reason of insanity because they're not competent to make that plea. So they can't be tried at all. And the question is then, what do you do with someone in that position? You just let them go because they're mentally ill? Well, no, the answer that the legislature came up with was a Murphy conservatorship. And so even if we get them off of the Murphy conservatorship, unless we can get them onto an LPS, that criminal case, if we get them off the Murphy, they go back to jail and have to go through that process all over again. So it's definitely true that LPS judges, that our mental health court judges, are more loose with their rulings in those contexts. You know, we had a guy who had robbed banks, and he, not with any weapons, and you know, the statute defines that as a violent crime. Robbery is a violent crime. And you know, we were making our argument this guy shouldn't be a Murphy because he's not dangerous because, and as I said at the time, he's robbed. You know, just because he robbed 15 banks, and the client from counsel table goes, "It was 16." It's like, we lost. So this is the standard that's used in 5250s. Each time you want to hold a person for longer, the burden goes up a tick. So for the temporary conservatorships, and it goes up a tick to a preponderance of the evidence standard, which is sort of more likely than not. It's like 51 to 49%. And then when you're trying to petition for a full permanent conservatorship for the year-long, then the standard goes up again to beyond a reasonable doubt. But this is the probable cause standard, and I'll read it for you. Evidence presented by must be highly and substantially more probable to be true than not, and the trier of fact must have a firm belief or conviction in its factuality. Sorry, that's clear and convincing evidence standard. I use this picture in a crisis intervention training with the police, and I was not asked back. Here's a probable cause definition. A state of facts that would lead a person of ordinary care and prudence to believe or entertain a strong suspicion that the person detained is mentally disordered and is a danger to self or others, or is gravely disabled. So basically, would lead a person of ordinary care and prudence to entertain a strong suspicion that it's true. So we talked about this a little bit with the city's general frustration with not being able, with seeing people who are mentally ill in the street, and I think it has a lot to do with, changing demographics in the city, but also, there is a really high demand, and we've seen property prices go up, and boarding care homes get sold off and become fewer and fewer. So when I started, I think there was 25 or so boarding care facilities in the city, and we're down to, I think it's like 4. So yeah, it's becoming a bigger problem.
Are there one or two common errors, or maybe not so common, but have high impact errors that it's good for us to be aware of, particularly with the 5250, but perhaps even the 5270, 5260, that you find in the course of your work? Errors made by the hospital, by the physician team.
The one that I find most common is that the doctor will do what doctors do and say, these are the symptoms. The person has delusions, the person believes something that isn't true, or whatever it might be. And all of that is relevant to a determination that the person may suffer from a mental disability. But in order for me to sustain a hold on GD, I have to find that all of these symptoms have an effect on his ability to provide for basic needs. I'll usually shepherd the doctor through the question. I say, okay, well, I'm satisfied that you've described some symptoms here, but how do those affect the ability to take care of himself or put him at risk, or put others at risk? So, and I understand that the doctor's trained in medicine, not in evidence, so that's right. That's, I think, the primary shortcoming.
My biggest pet peeve, and I see it as a mistake that doctors make, but I understandably, but still, I think worth being conscious of. And it's an argument that I make frequently in court, which is that to a man with a hammer, everything looks like a nail. And so when you're in the psychiatric context, everything looks symptomatic of psychosis, even things that a person without a mental health disorder might do outside of that context, where we wouldn't bat an eye on it, but in that context, it seems like a symptom. I'll give you an example. Just Friday, we had a case with a client who he had been hospitalized he had been in John George the day before. He got out. He might have run in front of a bus, or he might have flagged the bus down. It's unclear. But then he got on the bus and proceeded to, according to the police report, try and light the bus on fire, which he was unsuccessful doing. But was certainly concerning, and they hospitalized him for it. He was there in the hospital for about a week and a half, and in seclusion for most of that time. And he wasn't getting better in seclusion. Things were actually getting worse, it seemed. And then they got him out of seclusion and he made a turnaround, and they actually did a really good job with this patient. And by the time we had a hearing on Friday, he was looking great. He was cleaned up, wearing a collared shirt, speaking clearly, had a coherent plan, was ready to meet with his case manager. And so we went to court and we won the hearing and he was released. And you know, the issue then was, he was like, well, when can I get out of here? And he called his case manager because he was supposed to go meet with his case manager that day. And the case manager said, no, well, I'm on my way to you. And so by the time we had done the hearing on the unit, we had gone to a different unit to do another hearing and come back. And by the time we came back, there was this big scene because he was on the phone, he was on the payphone, and he was yelling. And so everyone had sort of gathered around to see what was going on. And he was clearly frustrated that he just won his hearing, he wants to leave, and now his case manager is saying, no, wait there, I'm coming there, and I don't know when I'm gonna be there. So he's yelling into the phone, and I said, what's going on? And one of the staff said, oh, he's over there, but he's on the phone, but he's not talking to anybody. There's nobody on the other line. And then the resident parroted that same thing to me, that he was clearly yelling at somebody on the other end of the phone with the payphone picked up, but they said he's not talking. There's nobody on the other line. He's just delusional, or he's venting his frustration. So I went over to talk to him because I was going to interrupt this non-phone call to try and calm him down and figure out what we could do. And it turns out his case manager was on the phone the whole time and was saying, no, just wait there, I'm coming there. So that's just an example of miscommunication, but it's something that outside of a psychiatric context probably wouldn't be an issue, but in a psychiatric facility it becomes sort of this game of telephone, quite literally, where, you know, one nurse says to, you know, a resident that he's not actually talking to anybody on the other line, and then that becomes a basis for why he's psychotic. Does that make sense?
There's this is a different sort of context, but in a Reese hearing, I oftentimes will get an affidavit from a doctor, probably written in a hurry, but we'll say that Ms. Bryan's representing the patient, and the affidavit says the patient denies she has a mental illness and refuses to take any medication for it because she says she doesn't need it. End of affidavit. And I'm saying, well, what about Ms. Bryan? She denies that she has a mental illness and she won't take any medicine. Does that mean that I automatically conclude that I should Reese her too?
Is that example?
I know, I get nervous every
It's
time.
important that you give a basis for why you think that the patient is mistaken to deny. That's especially difficult when the patient's on 5150 instead of 5250 because the doctor may not know the patient very well. But it is critical that I get some evidence to indicate that the patient's belief in their mental soundness is questionable.
And I saw Dr. Lindy, I think it was, in PDS handle that really well. Sort of the inverse of that, where the patient is saying, well, are you taking medication? Why should I take meds? I'm normal. Do you take meds? Do you take meds? Do you take meds? And he went around the room and asked Julian, he asked myself, and he asked Dr. Lindy. And Dr. Lindy's response was great. He said, well, I would if I had your condition. If I had bipolar disorder, I would certainly take meds. And I thought that was a good way.
Just with time running short, I wanted to ask questions about both ECT and also like interventional treatment. It's two parts. First is like with ECT, especially for patients on a hold on like an inpatient unit, we have to go like TCON with the ECT, like involuntary ECT request. But why is that? Like, because patients can, like, we deem that they have the capacity to like accept or refuse oral medications and such. So why can't a involuntary patient agree to voluntary ECT in the inpatient setting?
They actually
They
can.
can.
There
They
is a
can.
provision in the code.
Uh-huh.
The attorney for the patient needs to submit I think it's an affidavit to the effect that they endorse the patient's agreement to take the procedure voluntarily. But I think the reason for all these safeguards is a holdover from the days when ECT was regarded as far more invasive than some of these psychotropics, which have a much greater profile of adverse effects than ECT. It's
Yes.
just written in the code. They give the same protection as for a lobotomy for ECT, so it's a legislative holdover.
I think that's probably administrative within just sort of the hospital's policy or how they've done things to this point. That makes it easier to go through the conservator's office when requesting involuntary ECT. But I think there's a patient in general that just went through this on a 5270, and she got ECT voluntarily.
The second part is now with like, say, like transcranial magnetic stimulation, like TMS, or like ketamine infusion, which that can be like a one-time deal sometimes, like being developed. Like for IV ketamine, is that then going to fall under REIS? And for TMS, is that going to be kind of its own thing potentially? Like these two are rather new and novel, so where does it?
IV ketamine, if the patient wants to do it voluntarily, there's nothing in the statutes that I'm aware of that would prevent a voluntary patient, an involuntary patient from taking a ketamine infusion. As far as the TMS, I don't think that the statutes address that issue at all.
If a
Never
patient
written
is,
up before.
what about involuntary patient refusing ketamine, but you think it might be helpful as an IV infusion?
It has, for a REIS to apply, it has to be an antipsychotic medication as defined by the statute, which is any medicine that is used for a serious psychiatric crisis. If ketamine has reached that reputation, then it would fall under REIS.
Yeah, I mean, you can, in terms of TMS and ketamine, you could petition the court for anything. I mean, there's no limits on what you can ask for in terms of treatment. So if there's a treatment that's outside the box that that you think would really benefit this patient, we're going to represent the patient. Personally, I'm going to represent the patient. And if they don't want to be injected with ketamine, I'm going to tell the court why they shouldn't have to be. But that will butt up against whether they're competent to make that decision for themselves and whether the court feels like that treatment is necessary. So as long as you can make a case that you feel like this is the least invasive treatment that's necessary for this individual's condition and they lack capacity to make that decision, then you'll be able to do it. Because the court never gets involved in deciding which medications are right for who. And so if there's it's never going to get in the weeds with that. It can only order it can grant the conservator or the hospital, in the case of a REIS, the authority to give medication, period, antipsychotics, period. It would never say you can, except Julian does this as sort of part of his magic, which is if a patient's like, I'm not taking Haldol, I'll only take Prolixin, and the doctor says, all right, well, I only want to give you Prolixin anyway. Then Julian may write in the order, sort of as a win for the patient, no Haldol. And that also helps people feel like they were heard and they have they won, even though they're not being ordered to take Prolixin.
Well, we're at 1 o'clock, and 2 o'clock. So we're at the end of our time, but people want to ask some more questions if you have a few minutes. Otherwise, thank you very much for presenting to us today.